Hello everyone, welcome to TOLCNR. Suprabhat, good morning. In this video, we will see alternative dispute redressal including Arbitration Act. Total 4 questions asked under this examination. First question is which of the following is incorrect statement with respect to Lok Adalat? First option is no court fees is required in Lok Adalat. Lok Adalat can deal with all civil and criminal matters, and C option award of Lok Adalat is a deemed decree, and D option is no appeal against the award of Lok Adalat is allowed. Right answer is Lok Adalat can deal with all civil and criminal matters. Incorrect statement with respect to Lok Adalat is correct. Lok Adalat can deal with all civil and criminal matters, but it's not correct. Lok Adalat cannot deal with all civil and criminal matters, right? But Lok Adalat, no court fees is required in Lok Adalat, and Lok Adalat award of Lok Adalat is a deemed decree, and Lok Adalat no appeal against the award of Lok Adalat is allowed. Next question, which of the following is incorrect with respect to arbitration agreement as per the Arbitration and Conciliation Act 1996? A option, arbitration agreement may be written as well as oral. B option, arbitration agreement may be in the form of separate agreement. C option, arbitration agreement may be in the form of an arbitration clause in a contract. Option D, arbitration agreement may be for all or certain disputes which may arise between the parties. Option A is correct. Arbitration agreement may be written as well as oral. Next question, in which of the following circumstances an arbitrator may not be challenged as per the Arbitration and Conciliation Act 1995? Option A is when a justifiable doubt as to his independence arises. B option, when a justifiable doubt as to his impartiality arises. Option C, when he possesses the qualification agreed by the parties. And option D, when he becomes ineligible as per the 7th schedule of the Act. Option C is correct, when he possesses the qualifications agreed by the parties. Next question, according to section 7 clause 4 of the Arbitration and Conciliation Act, an arbitration agreement is in writing if it is contained in option A document signed by the parties. Option B, an exchange of letter, telex, telegram or other means of telecommunication which provide a record of the agreement. Option C, an exchange of statements of claim and defense in which the existence of the agreement is alleged by one party and not denied by the others. And option D, all of the above. Option D is correct, all of the above. An arbitration agreement is in writing if it is contained in a document signed by the party, contained in an exchange of letter, telex, telegram or other means of telecommunication which provide a record of the agreement, and an arbitration agreement is written if it is contained in an exchange of statement of claim and defense in which the existence of the agreement is alleged by one party and not denied by the others, right? Next question, waiver of right to object deviance from arbitration agreement is mentioned under dash of the Arbitration and Conciliation Act. Option A, section 7, option B, section 4, option C, section 20, option D, section 22. Option B is correct, section 4. Section 4, a waiver of right to object deviance from arbitration agreement is mentioned under Section 4 of the Arbitration and Conciliation Act. Next question, Section 9 of the Arbitration and Conciliation Act 1996 deals with option A, interim measures by the court, B option, discretionary power of the court, And option C, both A and B, and option D, none of the above. Option A is correct. Interim measures by the court under Section 9 of Arbitration and Conciliation Act 1996. Next question, VATNA BATNA stands for first option, bilateral agreement to negotiation and arbitration, and option B, best alternative to a negotiated agreement, and option C, bilateral trade negotiated agreement, and option D, none of the above. Option B is correct. BATNA stands for best alternative to a negotiated agreement. Next question, which among the following is not an ADR, alternative dispute resolution method under section 89 of CPC? Option A, mini trial. Option B, judicial settlement through lok adalat. Option C, conciliation, and option D, none of the above. Option A is correct. Mini trial is not an ADR method under section 89 of CPC. Next question, what is the maximum number of conciliators allowed in a conciliation proceedings? Option A 1, option B 2, and option 3, and option D, none of the above. Right answer is D, none of the above. Next question, what is the status of a settlement agreement in a conciliation proceeding? Option A, non-binding. Option B, same as a settlement award, and option C, unlike a settlement award, and option D, none of the above. Right option is B, same as a settlement award is the status of a settlement agreement in conciliation proceeding, right? Next question, which of the following is an innovative form of alternative dispute resolution mechanism? First option, Bar Council of India, B option, Election Commission, and C option, Comptroller and Auditor General CAG, and option D, Lok Adalat. Option D is correct. Lok Adalat is an innovative form of alternative dispute resolution mechanism. Next question, the language which is to be used in the arbitral proceeding is decided by first option, the tribunal, and B option, parties to decide by mutual understanding, and option C, the petitioner, and option D, defendant. Right answer is B. Option B is correct. Parties to decide by mutual understanding. Arbitral proceeding is decided by parties to decide by mutual understanding, right? Next question, the arbitral proceeding shall stand terminated. Option A, on making of the final award. Option B, by an order of the arbitral tribunal. Option C, when the parties to the dispute agree to terminate proceedings. Option D, all of the above. Right answer is D, all of the above. Arbitral proceedings shall stand terminated on making of the final award by an order of the arbitral tribunal and terminated when the parties to the dispute agree to terminate proceedings. Next question, every award of a Lok Adalat is deemed to be a first option, order of district collector, and option B, order of income tax commissioner, and option C, decree of a civil court, and option D, A and B. Option C is correct, decree of a civil court. Every award of a Lok Adalat is deemed to be a decree of a civil court, right? Next question, the Arbitration and Conciliation Act 1996 section 18 to 27 states first option, the conducting of arbitral proceedings. Option B, receipt and written communication, and option C, extent of judicial intervention, and option D, awarding final decision. Option A is correct, the conducting of a arbitral proceeding. Arbitration and Conciliation Act 1996 section 18 to 27 states the conducting of arbitral proceeding. Next question, under the Arbitration and Conciliation Act, an arbitration agreement may be in the form of first option, an arbitration clause in a contract only. Option B, in the form of separate agreement only. And option C, an agreement clause in a contract or in the form of a separate agreement. And option D is commercial custom. Option C is correct. Under the Arbitration and Conciliation Act, an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement, right? Next question. The arbitral tribunal shall not be bound by the option A CPC 1908 or Indian Evidence Act 1872. B option Indian Evidence Act 1872 and C option CPC 1908 and D option none of the above. Right answer is CPC 1908 or the Indian Evidence Act 1872. Option A is correct. The arbitral tribunal shall not be bound by the CPC and Evidence Act. Next question. The Indian Council of Arbitration was established in the year. First option 1956 and B option 1976 and C option 1965 and D option 1996. Right option is 1965. Question are the Indian Council of Arbitration was established in the year 1965. And next question. In India, the Arbitration and Conciliation Act was enacted. Option A 1996, option B 1998, option C 1999 and option D 2000. Option A is correct, 1996. Remember that the Indian Council of Arbitration was established in the year of 1965 and in India the Arbitration and Conciliation Act was enacted in 1996. Next question. The commencement of a arbitral proceeding is not dependent on interim relief being allowed or denied under Section 9 of the Arbitration and Conciliation Act 1996 Supreme Court, in which case held so. First option firm Ashok Traders versus Gurumukh Das Saluja. B option MMTC Limited versus Sterile Industries India Limited. And option C National Thermal Power Corporation versus Flowmore Private Limited. And option D Magma Leasing Limited versus NEPC Micon Limited. Option A is correct. Firm Ashok Traders versus Gurmukh Das Saluja. That's all for today. Thank you so much. If you like this session, please do like, share and subscribe to our channel. Thank you so much. Jai Hind.